Good afternoon to everyone present here today, and thank you very much for your interest in this intellectual discourse. First of all, I must say that I'm deeply indebted to all the eminent intellectuals gathered here today to share with us their views on the proposed introduction of Hudud in Malaysia. Without further ado, let me kindly allow me to briefly introduce all the speakers. For better particulars, you may wish to refer to the handout given to you earlier, which you can find on your seat. On my left, immediate left, is Mr. Lim Chee. Mr. Lim was the immediate past president of the Malaysian Bar Council and was appointed a member of the National Unity Consultative Council by the Prime Minister in November 2013. Next to Mr. Lim is Yang Berbahagia Dato Ambiga Sreenevasan. Dato Ambiga was also a past president of the Malaysian Bar and an active human rights advocate who co-chaired Persate 2.0. She is one of the 8 recipients of the U.S. International Woman of Courage Award in 2009. Next to Dato Ambiga is my learned colleague, Saudara Gamping Sieu, a senior advocate and solicitor, and a former Deputy Minister of Youth, Sports and Culture. On my right is the Honorable Reverend Herman Shastri. He is the General Secretary of the Council of Churches, Malaysia. Next to Reverend is the Dato Ang Chu Hong, who was the past president of the Buddhist Missionary Society of Malaysia. Next to Dato Ang is Encik Azhar Harun, a senior advocate and solicitor with keen interest in public interest cases, particularly those related to detention without trial and human rights issues. Next to Encik Azhar is Dr. O. E. San, a former political secretary to the current Prime Minister. Ladies and gentlemen, as the subject of discourse today involves inter alia religion, it can be highly charged. Thus, it is necessary for me, as the moderator, to lay a fundamental ground rule, i.e., we can agree to disagree with decorum. No one is to hijack this forum for their political or religious agenda. If anyone tries to do so, I'm afraid he'll be asked to stand down and leave. Let me remind all present here today, we are here to discuss the future of our country, given there are various interest groups, including political parties and individuals, chipping away at our federal constitution. Like all loyal Malaysians, we have a duty to stand up and be counted. We have to explain to the rakyat at large the implications and ramifications of proposed Hudud in Malaysia. Right-thinking and peace-loving Malaysians demand honesty from all politicians. All Malaysians must demand, I beg your pardon, their wakil rakyat be forthright and address our legitimate concerns and discomfort. With this opening line, I will now set up the format of the forum. All speakers are allowed 15 plus 5 minutes. At the end of 15 minutes, my colleague will ring a bell to signify that the speakers will have 5 minutes to round up his presentation. Mr. Lim Chee has been allocated a further 10 minutes because Apart from his presentation proper, he has kindly consented to assist me to lay out the legal framework so that all of us here may better appreciate the discourse, and for which I'm grateful. Now, may I call upon Mr. Lim to take to the rostrum. Mr. Lim, please.
Thank you, Dato Benson, and thank you to MCA for organizing this forum. I'm actually a mere appetizer, in the sense that I'm laying out the basic ingredients for today's talk in order for the other speakers to develop the theme further. I've been walking through, I hope you can see the slides, which hopefully will come up soon. Here we go. Second slide, please. I'll walk you through the position of Islam under the Federal Constitution, and the other speakers will develop that further. Islamic criminal law under the Federal Constitution, what is Hudud, why Hudud, and Hudud elsewhere, in particular Pakistan. Next slide. Now, what does our Federal Constitution say about the position of Islam? Simply this, Article 3, Bracket 1 says, Islam is the religion of the Federation, and it also goes on to say other religions may be practiced in peace and harmony. Then Article 11 entrenches the freedom of religion. Now, when a group of men drafted the Federal Constitution under the name of the Reed Commission, this is what they had to say about Islam. And I quote, there was a universal agreement that if any such provision were inserted, it must be made clear that it would not in any way affect the civil rights of non-Muslims. In the memorandum submitted by the Alliance, precursor to VM, it was stated, religion of Malaysia shall be Islam, the observance of its principles shall not impose any disability on non-Muslim nationals professing and practicing their own religions, and shall not imply that the state is not a secular state. That is the foundation for the proposition that Malaysia is a secular state. And I'll say more about that later. Next slide, please. Now, what do the judges have to say about the position of Islam? And you will see a slight change, a slight development so far as that is concerned. Sorry, can we go back to the earlier slide, please? Earlier? Thank you. Now, the Supreme Court, as it then was, Tun Syariah was Lord President, numero uno judge, judge number one. Of course, you know he was sacked later by Mahathir. He has made it clear, although he doesn't use the word he doesn't make a proposition as a secular state, but he makes it clear in this decision, and all the legal scholars and lawyers would quote Sheikh Omar as supporting authority for the proposition that Malaysia is a secular state. And this is the interpretation made by the Lord President. He says this: it is in this sense of dichotomy that the framers of the Constitution, i.e. the Reed Commission, understood the meaning of the word Islam in the context of Article 3, i.e. Islam is the religion federation. If it had been otherwise, there would have been another provision in the Constitution which would have the effect that any law contrary to the injunction of Islam would be void. Very clear. This is our Apex Court statement. Then, next, what I would regard as worrying development. This judge, Justice Muhammad Noor Abdullah, you may have come across his name. He retired as a Court of Appeal judge. He is also the chair of the Complaints Committee of MACC. He says this: Islam, I quote, Islam adalah agama bagi persekutuan, tapi agama lain boleh amalkan dengan aman dan damai. Nothing controversial there, peace and harmony. Bermakna Islam adalah agama utama di antara agama-agama lain yang dimiliki di negara ini. Islam bukan setara dengan agama lain. Bukan duduk berganding bahu atau berdiri sama tegak. Ia duduk di atas. Ia berjalan dahulu, terletak di tempat medan dan suaranya lantang kedengaran. Islam ibarat pokok jati tinggi tegur dan terampil. Now, this is probably the first of judicial decisions which appears to suggest the superiority of Islam. Then followed by the next case, the Allah case, where there were three separate decisions in the Court of Appeal, one of which, so far as it relates to Islam, Justice Apandi, who now sits in the federal court, says this, and I quote, "The article places the religion of Islam at par with the other basic structures of the Constitution, as it is the third in the order of precedence of the articles that were within the confines of Part 1 of the Constitution." By that he meant, well, it's in Article 3. Therefore, by virtue of the fact that the word Islam appears in Article 3, prior to anything else in the federal constitution, that then suggests priority. Now, he does talk about the structure, the basic structure of the constitution, and the other speakers will develop this theme further. Arguably, lawyers and scholars, even judges, will subscribe to the view that for our federal constitution, notwithstanding provisions for amendments to the federal constitution, and our federal constitution have been amended no less than 58 times. And that is just the amendment bill. We're not even talking about the actual provision being amended within the bill 58 times. So the view is that there is a basic structure of the federal constitution which cannot be amended. For example, a constitutional monarchy, separation of powers, and so forth. Right? But you can see there from Che Omar, from Syariah, what he has said about the position of Islam, how there's been a change in judicial thinking. Now, Islam itself, what more does the federal constitution say? Article 1211A, which was an amendment introduced by Mahathir in the early 90s, says that the civil courts have no jurisdiction in respect of matters within the jurisdiction of Sharia courts. In other words, they're very separate. Civil courts, you look after civil matters. Sharia court, you look after Sharia matters. But as you all know, in a similar forum last year or 2 years ago, we talked about unilateral conversion and how it falls in between the cracks into a land of no decision making, or worse, into a land where non-Muslim, notwithstanding the clear words of the Sharia law, are asked to appear in the Sharia courts if they want remedy. So even before I embark to talk about Islamic criminal law, even within Article 1211A, for personal matters, for family law matters, this dichotomy has really given rise to a lot of problems within our country. Then we have the state federal jurisdiction, all right, on the issue of criminal law. Right? List 2, 9th schedule of the Federal Constitution, refers to Islamic law and personal and family law of persons professing the religion of Islam. That comes within state jurisdiction. Islamic matters come within state jurisdiction, i.e., personal law plus criminal law. Although it doesn't use the word criminal law, but that's how it's understood. Sharia court's jurisdiction then says that offences against the precepts of Islam under any written laws, except for offences conferred by federal law. And then examples would be drinking liquor, unlawful sexual relations, not fasting during the month of Ramadan. And this legislation is important. Sharia Courts Criminal Jurisdiction Act 1965, Section 2. It is this piece of legislation which Kelantan seeks to introduce a private member's bill to amend in order to enlarge their jurisdiction. Because it is here that prescribes the limits of Islamic criminal law. And that is that maximum 3 years jail, fine at 5,000 ringgit, and 6 lashes. So the boundaries of punishment for Islamic criminal offences is prescribed by this legislation. Now, what is hudud? Hudud is a plural of had, then literal meaning, boundary or limit which separates and prevents one thing from intruding on another, fixed or specified punishment. I won't go too much into this because the other speakers will dwell on it. But let me walk you through the Kelantan legislation, which the Terengganu legislation is similar to it. As you would or should know, the Kelantan legislation was introduced in the State Legislative Assembly in 1993. Terengganu was 2002, if I'm not wrong. Now, adultery, I don't think I need to explain what is adultery. Punishment, stoning to death for a married person, whipping of 100 lashes plus 1 year imprisonment for getting married. Evidence required, 4 eyewitnesses to prove the act of adultery. All witnesses must be adult male Muslims of just character. Theft, first offense, amputation of right hand. Second offense, amputation of the left foot. Third and subsequent imprisonment in the opinion of the court are likely to lead to repentance. So it's 1, 2. Third offense is slanderous accusation. 80 lashes of the whip. The accusers are able to prove by 4 witnesses. Then highway robbery, death. Crucifixion, if the robbery is accompanied by killing. Wine drinking, whipping, 40 lashes minimum, 80 lashes maximum. You need to have oral testimony of 2 persons. Then apostasy, which is a 6th offense. The punishment, you are given a chance to repent. If you are reluctant to repent, there's death penalty and forfeiture of his or her property, and so on. So, these are the offenses and punishment one would find in the Terengganu and the Kelantan and Terengganu state statute books. But of course, they cannot be law yet, or cannot be law because of the Syariah criminal jurisdiction. Now, what is the rationale for Kelantan and Terengganu to introduce these laws into their statute books? I picked up the speech by now Dato, Tuan Haji Abdul Hadi. Now, psychological effect. I quote, hukuman itu benar-benar menggurunkan bakal-bakal penjenayah sehingga dia memberhentikan hasrat untuk melakukan jenayah. Deterrence. Then he says, yang pertama, aspek spiritual rohani menimbulkan keinsafan. Adanya pengawasan Allah yang Maha Mengetahui sehingga tidak boleh disembunyikan, termasuklah segala yang tersirat dalam hati manusia. Yang kedua, aspek zahir melalui tindakan undang-undang oleh kerajaan dengan keterangan dan syarat-syaratnya yang ketat dan tegas. Kesemua undang-undang Islam itu merangkumi segala aspek yang perlu dalam kehidupan manusia. Then, widely accepted by Muslims and non-Muslims, he says, I quote, kesemua undang-undang ini pernah dilaksanakan dengan cemerlangnya dan diterima bukan sahaja oleh orang-orang Islam, bahkan diterima juga oleh orang-orang yang bukan Islam yang merasai betapa baik kesannya. And then finally, undang-undang Islam ini telah mewujudkan keadilan, keamanan dan mutlak. I'll say more about this later. I will now go into, at a very basic level, 8 reasons why hudud is actually a legal and sociological impossibility. The first of which is the fact that Malaysia is a secular state. I already made reference to recommission, the Supreme Court decision in Chee Omar, but let us also find out what did our former prime ministers have to say. Tunku Abdul Rahman said, I quote, the country has a multiracial population with various beliefs. Malaysia must continue as a secular state with Islam as the official religion. Proceed on, he says, the nation can still be functional as a secular state with Islam as the official religion. What does Mahathir have to say? And I quote this, if in a multiracial country like Malaysia, the Muslims had to have their hands amputated for theft, and the non-Muslims did not, the result would be that Muslims who have lost their hand will be unable to compete with the non-Muslims. It must be emphasized that the government's attempt to inculcate Islamic values in the administration should not result in it becoming weak, passive, or chaotic. So the two reasons here are, firstly, we're a secular state. Secondly, equality before the law, and that is entrenched in Article 8. Third reason, the federal state division. I won't read this, but in essence, criminal law and procedure and administration of justice falls and lies in control and the hand of the federal government. You cannot have the state government through Islamic matters, through governing matters over persons professing the religion of Islam, to then impose on them a separate criminal legal system separate from the rest of the country. I will come to this a bit later, but I would like to say this. There is no jurisdiction where there is duality of criminal legal system. It's either all hudud or nothing. The countries which have hudud, Sudan, Saudi Arabia, Afghanistan, Iran, Iraq, Pakistan, these countries, it's all hudud applicable to everybody. Nigeria, they have the 11 or 12 northern states which apply it. And in those northern states, the majority are Muslims. But it is also applicable to non-Muslims, but there are problems in those states in Nigeria. And I'll talk a little bit more about that later. And Pakistan and Sudan are the two countries I'll talk about as under hudud elsewhere. So you have here, because of the federal state divide of powers and jurisdiction, a legal impossibility for hudud to be introduced. I now come to the application of procedural laws. Now, what would be admissible and good enough to establish conviction in the non-Islamic criminal jurisprudence will no longer be so in the Islamic jurisprudence. One of which, of course, is proof of adultery, for example. Yeah, under the Kelantan legislation, you have the requirement of 4 eyewitnesses, all of whom must be Muslim male. Then there's also the violation of Article 5, the right to life. And lawyers would argue that right to life includes the right not to be subject to torture, inhumane or degrading treatment or punishment. And I'll develop that a bit more later. Now, so far as international human rights go, here, although Malaysia is not signatory to the International Covenant on Civil and Political Rights, it is arguable that under international customary human rights law, punishment meted out by hudud such as amputation, death penalty, and so forth, violates and contradicts what is called the International Covenant on Civil and Political Rights, or ICCPR. Then we have, now this is certainly law in Malaysia. We are a signatory to CEDAW, Convention on Elimination of Discrimination Against Women, and in a High Court decision, in 2 High Court decisions, we have 2 very brave, intelligent High Court judges who took the view that CEDAW, this convention, is applicable almost as of right as domestic law. Okay. And therefore, if that is the case, hudud, because of its requirements, or rather because of its gender bias, is actually a violation of CEDAW and therefore a violation of Malaysian common law. So we have the Indira Gandhi case, conversion case. We have Nur Fadilah, the pregnant teacher case. Of course, both cases are pending appeal. We await what the appellate courts have to say. Now, let us address the issue or the rationale of hudud raised by Hudud, i.e. deterrence effect. I have up here, under the ranking of Global Peace Index, where the countries which have hudud and where Malaysia stands, so far as crime levels go. And Malaysia is the lowest amongst all these other countries, of course Afghanistan, Iran, Iraq, Pakistan, Nigeria, Saudi Arabia, Sudan, and Yemen. So this ranking debunks the argument that hudud can be a deterrence. Now, what about hudud elsewhere? And I'm focusing here on Pakistan. Now, Pakistan introduced hudud in 1979 when General Ziaul Haq took over. Now, it's very interesting, but if you study history of why hudud is introduced in the countries around the world, including recently Brunei, the suggestion by political analysts appear to be, and historians, that it is used as a means to entrench political power. But that is, of course, a suggestion. Now, percentage of women charged under Hudud crimes in 2004 in Pakistan, 88%. Right? 88% of women. Then out of the 88% of women charged with Hudud offences, 72% of them were charged under the offences of zina. Right? Then, in Pakistan, this is a development of how unfair it is towards womankind in Pakistan, the implementation of Hudud. More than 70% of women in police custody were subjected to rape by police officials. 96, up to 90% of recorded rape victims were in jail because they failed to produce credible witnesses to support the charges of rape. In 2002, there were an estimated 2,200 women prisoners in Pakistan, most of whom were awaiting trial or were convicted under the Hudud laws. Then, in 2006, their own High Commission, Human Rights Commission statistics, women aged over 70 years to girls as young as 11 had been imprisoned on charges of zina. Each year, over 1,500 cases were registered against women. I'll leave it to the other speakers to talk more about the offense of zina. Now, in Sudan, their own human rights organization have called for the repeal of Hudud. In Pakistan, their National Commission on Status of Women have called for the repeal of Hudud. The Pakistan Women Lawyers Association have also called for a repeal of Hudud. Now, one of the arguments out there, and this is my eighth and final argument, which the press has reported on but not developed much in the public discourse, is the position of Sabah and Sarawak. Now, a lot of people think Sabah and Sarawak is just another state in the Federation. No. They are considered special so far on an equal standing to Peninsula as opposed to just merely a state. Now, you would have come across the 18 and 20 point agreement, and you're wondering, what is this document? This is a document which actually lays down the conditions of these of Sabah, Sarawak entering the Federation in 1963. Some of the points in the points of agreement were incorporated in the federal constitution, some were not. Now, depending on the lawyer or legal scholar you speak to, some will say these two documents are of zero legal effect. Some will say they are of some legal significance, useful in the interpretation of the federal constitution. So let us now take the position they are useful in the interpretation of the federal constitution, but if you speak to any Sabahat or Sarawakian, they will say it is of great legal effect. Essentially, point one says, while there was no objection to Islam being a national religion of Malaysia, there should be no state religion in Sabah or Sarawak, and the provisions relating to Islam in the present constitution of Malaya should not apply to Sabah, Sarawak. Then we have Article 161E of our federal constitution. Bracket 2, no amendment shall be made to the constitution without the concurrence of the Yang Ketua Negeri of the state of Sabah or Sarawak, and these are the matters: religion in the state, the use in the state or in parliament of any language and special treatment of natives of the state. So these are the 8 reasons why the Hudud is a legal and sociological impossibility for Malaysia. And now I will leave it to the other speakers to develop some of these themes further. Thank you.
Thank you very much, my name is Friend Chee. I'd like to inform the audience that during the Q&A question, later, after all the speakers have spoken, we will have the Q&A session. However, those who do not wish to stand up to ask a question, but will nevertheless want your question to be answered, you can actually write on a piece of paper and hand it to me, right? So, in order for you not to forget the question that you want to ask, you may just wish to jot it down and hand it to me if you so wish it. Now, with that, may I respectfully call upon the next speaker, Encik Azhar Harun, to present his speech. Thank you.
you very much, Dato Benson. Distinguished speakers, ladies and gentlemen. My name is Azhar. I have to make something very clear before I start my talk. I'm Malay, I'm Muslim, but I'm here today as a Malaysian. I have to make that clear. I have to make that clear because I think the discourse or debate on Hudud in Malaysia has been hijacked by religionists and has been hijacked on religionist ground. The rhetoric nowadays when we talk about Hudud is that non-Muslims do not have any right to talk about Hudud because you all are non-Muslim. Hudud don't apply to non-Muslim. And if a Malay Muslim like me is anti-Hudud or I do not want to implement Hudud, I am against Islam and against my God, and therefore I am as good as being a non-Muslim. So that is the rhetoric. And that is why I say the discourse and debate on Hudud in Malaysia today has been hijacked by religionists on religionist ground. We have to pull that back on track now. And how do we do that? We have to look at the country's constitution. We have to look at our system of law. We have to look at our societal order, our way of life from the day this country was born. And that is the only way of debating and discussing debating and discussing on Hudud in Malaysia, not on religion ground. I say Hudud ought not to be implemented, not because I'm not a Muslim, and not because I am against Hudud. No. I say that because we are Malaysian. From 31st August 1957, we have chosen to lead a certain way of life. We have chosen to spell out all our aspirations as a people and as a nation in our constitution. And throughout the course of time, we have cemented that through our Rukun Negara in 1969, 1970. We have cemented that in Vision 2020. Where is it in the Rukun Negara or Vision 2020? Did we say we are going to be a progressive and liberal society with Hudud law? Tak ada. So why are we doing this now? The answer is simple. It's political. Past has a wet dream. I have always said this, and I will repeat it. They have a wet dream. And their wet dream is an Islamic state and Hudud. That's their wet dream. And no matter what they say, no matter what they agree with Pakatan Rakyat, welfare state and whatever, they will always one day come back to Hudud. Because that is their base. You know, if that is not lying, I do not know what is. So, we are used to this way of life. We have our system of law, our administration of justice, our administration of criminal justice. When Tun Dr. Mahathir, in all his wisdom, or the lack of it, introduced the parallel jurisdiction between Syariah court and the High Court, he never foresee the problem that he was going to create. All the conversion problems, the marital problems, the forced conversion of children problems, and the conflict which arise from all those problems. Now the High Court do not know what to do. The Syariah court imposed their will even on non-Muslim, and now their suggestion to say that we say that non-Muslim should go to the Syariah court. all these things were not thought through. Can we all imagine if we introduce Hudud, what will occur in 15 years' time? Just now at lunch, I posed one question. To those of you who believe Hudud don't apply to you, I just posed this question. A and B are Chinese. They have got a daughter. A Malay Muslim guy murdered the daughter. He was charged in the Syariah court under Hudud. He offered 3 million blood money. The wife decided to take it, the husband don't agree. Or, make it stronger. The husband decided to take it, the wife don't want to take it. The Syariah court said, hey, blood money is already accepted, he's forgiven. He's free. Does that affect you?
Yes.
And when we talk about Hudud, you know, as Muslim, if the government intends to introduce Hudud as per the Al-Quran, as per the God's word, I agree. But we have to be realistic. We have to be prepared to face reality, i.e., 99% of the criminal will be free. That is the true jurisprudential Islam, insofar as Sharia, insofar as Hudud is concerned. 4 reliable witnesses. The witnesses will be on trial. If I prove the witness have in the past lied once, it's evident I have got no credibility. I'm a lawyer. It makes my life far easier under Hudud. But if you follow Hudud, yeah, the Kelantan and Terengganu enactment, alcohol consumption falls under the enactment. The Quran never say anything about that. So they say it falls under ta'zir. And here is the problem. 99% of the so-called Hudud law imposed in Pakistan, in Brunei, and in the Terengganu state enactment, and the Kelantan state enactment, and elsewhere, are all ta'zir. And these ta'zir have been formulated by ulama 1,000 years ago. Why do we do ta'zir now? Under Hudud, in the Quran, there are only 5. 5. Qisas, which says, if someone murders someone else, and if he is not forgiven by the family, or if his blood money is not accepted, that murder is punishable by death. Number 1. Number 2, sex between unmarried people. That's Hudud. But the penalty is not stoning. Yeah? The penalty is 100 lashes. In the Quran. Where does the stoning come from? Ta'zir. Hadith. Ulama ruling. Yeah? And the way the caning was done in those days is not like our caning in the prison, you know. I cannot raise the rotan more than my shoulder. One of the this is a true Hudud. I'm for it. Number 3. This is very important. This is a Hudud. But past, dominated by males, they never talk about this. This is Hudud, yeah? A man who falsely accused women of immorality without being able to prove it is punishable by Hudud. Where is that in the Kelantan and Terengganu enactment? And why? The burden is on the man. who accuses a woman of immorality to prove her immorality. Otherwise, he is punishable by Buddhist. Yeah? And why is it in the Kelantan and Terengganu enactment, the burden has been reversed? If a woman is pregnant and she cannot prove that she was raped, she is punishable under Hudud, under that enactment. Why has it been reversed? Where does it come from? And in Terengganu also, if a woman complains that she was raped, but she cannot prove that rape, she will be lashed. Why is that? And there are many people who say rape can never be proven by the women because they need 4 witnesses. There are strong scholarly opinions which say rape do not need 4 witnesses. But that has never been articulated. How to rape? Who will be so stupid to commit rape in front of 4 people? So because of all this concealment, Hudud has been portrayed in such a bad light. Non-Muslim will ask, how come a rape for? But the scholarly opinion which say rape do not need 4 witnesses have never been highlighted. I'm highlighting it to you today. So, the next Hudud is highway robbery. Highway robbery is highway robbery. And the last one is theft. But there are, all these things have been thought over, and there have been scholarly opinion, like theft. Theft of edibles is not Hudud. And the theft must be done in stealth. In stealth, meaning snatch theft is not in theft. It's not in stealth, so that's not Hudud. It must be done in stealth. So meaning, I go and do steal somebody, nobody knows. Okay, but then there wouldn't be any 4 witnesses. So all these things you must think about it. And there is no Hudud for robbery in a house. Now that would fall under takzir. Yeah. Why highway robbery? Because those days, highway robbery, the merchant caravan, were widespread. There were no banks to rob. So there wasn't any Hudud for robbing a bank. So that will come, of course, under takzir. Yeah? So there must be a revisiting of all these principles. And a new takzir probably could be formulated. But having said that, why are we doing it? We have our penal code now. We have our criminal justice system. Why must we change? Why? Because all the religion, on religion, every state have authority. So do we want to have 12 Syariah court, 12 Attorney General chambers, 12 police force? Because you have to have investigative powers. Our current police force do not have investigative powers over Syariah. So you have to have 12 police forces, 12 prosecution chambers, okay, and probably 12 ways of appointing judges and training lawyers. And what about Article 8, equality before the law? And what about our history? Our history. Chee has articulated on the history behind Article 3, Islam being the religion of the Federation. Let me just expand that a bit. Initially, Islam being the religion of the Federation, the Reed Commission did not put in the Constitution. And you know why? Because the rulers did not want it. Our rulers did not want it. And this was the report. majority of us think that it is best to leave the matter on this basis, looking to the fact that Council for the Rulers said to us, it is their Highnesses' considered view that it would not be desirable to insert that in our constitution. But later, the rulers relented and said, okay, to put that in the constitution. One of the member of the League Commission, Justice Azhar Harun from Pakistan, he said in his report, around the world, he said, there are 16 countries which spell out certain religion as their religion of federation. He said, among the Christian countries, Ireland, Norway, Denmark, Spain, Argentina, Bolivia, whatever, spell out that Christianity shall be the religion of the federation. But it doesn't mean that they are a Christian country. They are still a secular country. So why not Malaysia, is it? We just put it in. But it means that Malaysia is still a secular country. Then what happened was, the Alliance apparently agreed to this insertion. But in the book entitled The Making of the Malayan Constitution by Joseph Fernandez, this is very important. The UMNO leaders contended that provision for an official religion would have an important psychological impact on the Malay. But in deference to the objection of the rulers and the concern of non-Muslims, the Alliance agreed that the new article should include two provisos. First, that it would not affect the position of the rulers. Second, that the practice and propagation of other religion in the Federation would be assured under the Constitution. And this is important. I quote in verbatim. The MCA and MIC representatives did not raise any objection to the new article, despite protests by many non-Muslim organizations, as they were given to understand by their UMNO colleagues that it was intended to have symbolic significance than practical effect, and that the civil right of the non-Muslim would not be affected. That is the historical background. And why are we now clamoring for Islamic this and Islamic that, Hudud this and Hudud that? That is the basis of the establishment of this nation, of ours. And that is my stand. I'm not against Islam. That is my stand. Whether my stand goes against my God, that is between me and my God. At the end of the day, I will answer to Him. And nobody will get around me to help me. That is my stand. And that is why I say the discourse on Hudud has been hijacked. It is up to us to bring it back to track. I have been called a kafir many times. I couldn't be bothered. Because whatever I do is for myself. At the end of the day, when I die, 6 feet in the ground, nobody is going to be around with me. Nobody. Not PAS, not UMNO, not MCA, not IFIC. None. And if we read the handset of the British Parliament while debating the Independence of Malaya Act, 1957, they are all saying the insertion of this article does not mean that Malaysia is not a secular state. And when at the end of the day, that provision was inserted, Article 3, it was thought that the Reed Commission might felt a bit slighted because they recommended for the non-insertion. Yeah. So in any way, in an effort to mollify the Reed Commission, the Colonial Secretary, Lennox Boyd, wrote to Lord Reed a letter dated 31st May 1957. he offered tribute and gratitude to the remarkable work done by the Reid Commission. And this is what inter alia stated in that letter. The rulers, as you know, changed their tune about Islam, and they and the government presented a united front in favor of making Islam a state religion, even though Malaya is to be a secular state. That is what history tells us. So we have got to bring this back on track so that we are not lost in all this rhetoric. That is all that I will say. Thank you.
Deputy Minister of Youth, Sport and Culture.
Thank you, Dr. Benson, and thanks to the organizers and Dr. Tionglo, Dr. Editor, and Dato to H1 making this forum possible. First and foremost, I think we have a living example today. Educated, legal scholar, who speaks his mind as a Muslim, Mr. Azhar Harun. We give him a round of applause. From MCA's point of view, this afternoon I'm going to bring up 3 points, three views. First is MCA's stance and the reasoning why we do not agree with the implementation of Hudud. 2 is the historical perspective, and third is some misconceptions about the legal points, why I feel, and after reading the legal documents, that we do not need to amend the constitutions to implement Hudud, and it is therefore almost most important at this juncture that it is a crossroad for this nation that we must make a stand very clear. And actually, at the end of it, I will sum it up and call upon our Muslim friends all to stand up for the occasion. Now, first, allow me to express MCA's political stance. We are against the implementation of Hudud. It's no doubt about that. Of course, there will be quarters. There will be people accusing MCAs for being anti-Islam. And we're telling you, and we're telling everybody, and I'm sure everyone in this room, no one will be against Islam as a religion, as a faith. I think I'm clear on this one. But through Hudud, that's what Sadhana Azhar said, or even past version of Hudud, is the words, or even past belief, what we think is the words of God. The true Hudud is the words of God Allah, reduced into writing in the Holy Quran, and is also written partly in the Sunnah Hadith. And there's no question about that. And on the other hand, we all believe in the freedom of religion, we believe in the freedom of faith, and therefore, because of this fundamental belief, we must understand and comprehend. It is difficult. Indeed, we must understand that we shouldn't expect our Muslim brothers and sisters openly question the words of God reduced into Holy Scripture. You ask them questions and even to reject openly, say, look, Hudud is not part of the Holy Quran. It's not true. It is written there. And that is the first time we must understand the Muslims, brothers, sisters, their psychology, and their religious belief. And therefore, I think it will not be reasonable for us to expect our Muslim brothers and sisters to reject Hudud as it is. Just to reject. I'm against Hudud for Muslim friends of ours to say so. I think it's not reasonable for us to expect our Muslim friends to say exactly that. Because it's written in the Holy Scripture. And we believe in freedom of religion and faith, so we should expect that stand. But that said, on the other hand, we observe the bulk of the OIC countries, or Muslim populated countries. OIC countries about 56 or 57. Throughout the world, there are about 1.6 billion of Muslims. That represent about 23% of the world population, of a great religion. But out of these 56, 57 countries, there are only 14 countries implement Hudud. Why? And these 14 countries definitely do not represent the entire 1.6 billion of the population. Why? Number two, there were enough, there are plenty of Islamic scholars' view. They call for what we call suspension or moratorium of the implementation or applications of Hudud. What does that mean? They were of the view that we should, at this juncture for the Islamic world, that at this juncture, that we should emulate the practice of Caliph Omar Al-Khattab. Who is Caliph Omar Al-Khattab? The Muslim will tell you is the companion and the second successors of Prophet, peace be upon him. And is the most one of the rightly guided Caliph accepted by Shia, Sunni, Khariji, Sufis, Ahmadiyya, whatever we call it, whatever denomination, whatever schools, whatever mazhab, they all accept the fact that Caliph Omar is one of the rightly guided Caliph accepted by all. And during his era, he suspended the implementation of Hudud for a very simple reason. Because there was famine, there was drought, and then the environment, the social context then was unsuitable for the implementation of Hudud. And the whole theory is what? We must understand one thing. The great religion of Islam is a religion for compassion, religions for justice, equality, and advocate moderations or what they call wasatiyah. So these are the core central values of Islamic teaching. And these are the values, I think, is common to all great religions, be it Christianity or the Chinese or the Hinduism. This is common to all. This is what we call the universal values. So there was a reason why, during that period of time, even the most trusted companion of the Prophet was of the view that it shouldn't be implemented. What about today? What about today? If we believe if the Muslim world, my understanding is about these Muslim scholars, they believe that their priorities is in fact in the propagation of Islam to teach the core values of justice, equality, moderations, and compassion. This is the overwhelming, overriding Islamic values. So if any practice, any implementations of rules and regulations that run counter to this is a disservice and will cause injustice or gross injustice to Islam. And that is, to my understanding, is the majority legal and Islamic scholars' view. Domestic, I'm not very sure, maybe Azhar can stand guided. But internationally, that is the popular and the trend. Now, ladies and gentlemen, from MCA points of view, we agree with the fact that at this juncture, the contemporary era, present social context, the implementation of Hudud is not suitable. As simple as that. Much as we respect our Muslim friends that they do agree, they do believe, they do know that the Hudud is the words written down in Holy Quran and Parabah Sunnah. Whatever version. And of course, past versions to me is a twisted version. But be that as may, but in this era, from MCA points of view, it is simply not suitable to apply. Now, one of the reasons is, in Islamic teaching, as my understanding is, they are looking for a just society. But given the current world trend, not only in Malaysia, the world over, it's all the same. You have people who are privileged, who are not subject to laws, who enjoy extra advantages, or even immunity. You have wide gap of income distribution, wealth and income distribution. You have illiteracy. Your people are not educated. They are across the sections in the society, all society in the world now, they are the gap of rich people and people who are still trapped under poverty trap, or are still in the poverty trap. So a society of this nature, according to the Islamic scholars, as far as I understand, Hudud should not be applied. And that, coupled with the fact that in Malaysia, we are not 100% or even not 98% of a Muslim nation. No. At best, about 60% are Muslims. And what about the social structure of this country. Our social structure of the country is multiracial, pluralism, different traditions, and whenever we say Malaysia truly Asia, and why is it truly Asia? Because of four great civilizations of the world. You can find it in Malaysia. The Chinese, the Hinduism, and Islam, and the Christianity. You can all find it all in Malaysia. Other civilizations, probably like Egyptian, maybe, well, no, probably you can only remember the pharaoh and the pyramid. And the great civilizations, great religions, you all can all find in this country. And therefore, we cherish what? What do we cherish? We cherish the universal values, not only one particular values. But if Islamic value, Christianity values, or even the Chinese Taoism or Buddhism values, or Hinduism values, which is common to all, the common factors for all, we all agree. And this is how this country is built. And therefore, from MCA points of view, if we want to implement Hudud, by imposing one particular version or twisted versions of past Hudud to impose on everybody, I think it's not fair. We disagree fundamentally. And that is MCA points of view. And therefore, on this count, on this political view, I think it is important for us to understand and to make a clear distinction. Okay? The fact that the Malay Muslim in particular, they accept Hudud is in the Quran and Sunnah. But to implement it is a wholly separate issue. And therefore, you see, PM in 2001, 24th of September, he openly said that PN is not going to implement Hudud. No, why is it not going to implement Hudud? As I said, the contemporary era, the social context, and the multi-racial social environments of this country is simply not suitable to apply. If you implement that, it's going to cause greater gross injustice, inequality, one country, two systems, and one country, two people, and people are divided because of their faith and religion, and I think this is going to do a terrible disservice to Islam. And therefore, a lot of Muslim leaders, moderate Muslim leaders, scholars, and NGOs openly are against implementation of Hudud. Now, number two is about the historical context. I think Azhar and Chee has mentioned some before. MCA as one of the founding political parties of this nation, and we have a duty. MCA has a duty to make it very clear. As what Azhar said earlier on, that in 1956, MCA did not object to the insertion of Islam as the religions of the federation. We did not object, but you look back on the historic documents. I even talked to Professor Joseph Fernandez personally. He told me he did his research. Where did he get all his original documents? From MCA. Basement 2, he told me. He got all the original documents from MCA to do his research, and he came up with publication. And throughout the historical events leading to the formation of this country, three commissions, the working papers, the declassified colonial documents, and the working committee meetings, and the alliance report, and Greece report, of course, and after that the cohort reports in the formations of Malaysia, not Malaysia. All this was discussed time and again. When the bill was presented, the constitutional bill was presented in 1957 in the Parliament as the legislature in Malaysia then, it was openly accepted from the alliance. Even Tun Tan Siew Sin, representing alliance, openly endorsed and seconded the bill of constitution bill. And there was no amendments to the constitution bill then, and it was not very clear. Malaysia is to remain a secular nation. You may have Islam as an official religion, and that religion was incorporated, inserted on the assurance time and again, many times, for one major reason. What was the reason? It was inserted for ceremonial and ritual reason. It's just like British. When the Parliament convened the new session, then someone will carry a lot of ceremony will be going on. And then the Queen will come in, and then will pray to the Lord. So it is for ritual and ceremony purpose. It's just like when our Parliament was convened, and the sessions were convened, and therefore there was some ceremony, people marching in, carrying some things and all that. And that is the ceremonial reasons why, one of the major reasons why Islam was incorporated, inserted for that reason. And there was assurance. And what Azhar mentioned just now about Justice, Pakistani justice, when he prepared the recognition, initially he said it shouldn't be inserted. Later he put it probably after some research. He was a Muslim. He said this insertion of Islam as the religion for the federation is the exact word, innocuous, harmless, innocuous. There's no practical substance in the insertion of that. So that is something, the historical developments over the year. Malaysia is a secular nation, and there's no question about that. But of course, we do understand. There are people, there are even some jurists or legal scholars, even some religious people try to rewrite our constitution. In the current cases, civil cases about the Indira Gandhi, for example, or some other cases that I represented parties to on an amicus curiae basis, to present MCA points of view. And that's this nation. The basic structure has always been secular. Even Mahathir, when in 2001, in Gerakan's AGM, he openly said, he pronounced that Malaysia is Negara Islam. The question of Negara Islam, we have to make it very clear. Tunling at that time, and there are people who said MCA never object, I think that's nonsense. That's bullshit. Tunling at that time make it very clear. There's a huge difference between what we understand as a Negara Islam, as a social reality, because they are populated with Muslims, and Islamic theocracy as a political structure. This is a huge difference. Even for that matter, when Tun Mahathir pronounced it, Ni Aziz comment very simple. Ni Aziz comment. You can call a wood borrow. Wood borrow is those construction site with wood borrows to carry things. You can call it a Mercedes if you want. But Malaysia is a circular country. And this is what Aziz said. He was saying that Tun Mahathir was misleading. So, in other words, the substance, the actual fact of this country, the content is still circular in nature. And the circular institution is what we have now. And of course, we have the state constitutions giving in the family matters, inheritance, property inheritance matters, and some Islamic faith issues to be handled by the Sharia court. But even then, that is the creation of the constitution, the creation of the federal law. And that one, I think some of the learned councils will explain to you all later. Now, finally, is their view is about to amend the federal constitutions to implement the law. I think we have to question two things. First, there's a movement which says, very simple, we don't need to amend constitution, which requires 2/3 legislators' consent. No. All we need to do is we pass a federal law by simple majority, increase or enhance the criminal jurisdictions of Sharia court. Okay. Whether that can run, I think that can probably go through. If that was to go through, of course we can challenge. This is against Article 8, equality provisions of the federal constitution. We can say this is against the article, the right to life article, and or they can challenge that. 3 years, 5 years, 10 years in the federal court, and step by step going all up, challenge a legislative decision, and this could be difficult. Number two is I think it's the simplest and easiest is the hukum, the punishment, the criminal punishments of amputation, stoning, whatever that may be. All you need to do is pass to amend the penal code, criminal procedures and evidence act. And whether again that runs counter to contravene the federal constitution is a different issue. All you need to do is okay, now theft, punishable by how many years and plus how many, what sort of fine. Okay, now we pass a law to incorporate amputation as part of the punishment. Can't that be done? That I don't think it requires to amend the constitution. But of course you can challenge, amputation is degrading, it's inhuman, and therefore runs against the rights of life provisions of federal constitution. It's a long process. And then the question is, because you have a simple majority who endorses, and then the democratic arguments will be confused. Then we're going to argue this and argue that. 3 years, 5 years, 2 elections after that. We will not know what will happen after that. And therefore, it is important at this juncture, we must make our mind very clear. If we do not agree with the implementations of Hudud, we make it clear with good reasoning and why. Islamic scholars disagree, international phenomena disagree, international views disagree, and Malaysia's population structures and basic structure of this country, its historical background, and what we want now is we disagree, and we make it loud and clear, friends. It's easy for us, and if I have to ask the non-Muslims throughout the nation, those who understand the issue, I would say easily, the non-Muslim, 95% will say no, if not 99%, say no. But that's not good enough, friends. We must encourage our Muslim friends, Muslim leaders, the silent majority, someone like Azhar, openly give them the courage and stand by them to openly disagree with the implementation of it. And to quote what Prophet Muhammad peace be upon him used to say, that if the mountain doesn't come to you, please walk to the mountain. And I think at this juncture, at this historical juncture, that not only MCA, all the people, the non-Muslim, if you have Muslim friends, please reach out to them and hope that they can agree with us and they stand up and for the sake of this nation, for the sake of for the long-term national interests of this nation. So these are things that I would like to take the opportunity to call upon the members of public, non-Muslim, Muslim alike, to support this movement. And I have to say sorry, apologize, I have to leave earlier, and I may not be able to stay on for some prior engagement. And thank you very much again for giving me the opportunity to share with you my views. Thank you.
Thank you very much for the very big issue. Now we have now is Dato Ambiga ready to please welcome. Thank you.
Yeah, I have slide. Yeah, thank you. Could you go to the first slide, please? Thank you. First of all, I'd like to say thank you very much to MCA inviting me for the first time to this place. Well, actually, it's the second time. I lied. It's the second time. I was invited just prior to the elections to speak. Anyway, I'm not sure I will get another invitation. So you will have to bear with what I'm going to say. Now, we know that Hudud has now been, the proposal, the private member's bill, has now been referred to a technical committee. This is by agreement, etc., etc. Now, what concerns me about that is that both UMNO and PAS appear to have a consensus. I can understand that's PAS' position. I'm surprised that it's UMNO's position. That bill has passed the constitutional test. You only send it to a technical committee to work out details. I want to know whether they have asked the primary question, both of them, whether this legislation offends the Constitution. Now, this is Article 4 of the Federal Constitution. As we all know, it is the supreme law of the land, and any law passed after Merdeka Day which is inconsistent with this Constitution shall, to the extent of inconsistency, be void. Now, that means this Constitution prevails over all laws. All laws are subject to our Constitution. If it offends anything in the Constitution, it can be declared null and void by the courts. Now, next slide, please. This is what is called the basic structure. You will come across this term very often in this discussion about Buddhism, and it is very important that you understand what it is. A basic structure is certain basic features of the Constitution that can never be changed, even if you get 2/3 majority. All right? For example, tomorrow, can you, with 2/3 majority, decide we don't want a parliament. You can never do it, even if you have 2/3 majority in the House. Can you, tomorrow, with a 2/3 majority, say, Islam is no longer the religion of the Federation? You can never do it. That's another basic feature of our Constitution. So there are certain basic features you can never change, even if you get unanimous agreement. That's what basic structure means. And our structure is basically along the Westminster model. You have your separation of powers, parliament, etc., judiciary, executive, and it works. And it's worked for more than 50 years. And we don't want this constitution changed after it has worked so well for us for so many years. Now, the constitution is secular. You've heard that from the lawyers earlier on. I think that is settled. Everybody thinks secular is a bad word. Why? Secular is a good word. Secular means everybody's rights are protected. In India, the Hindu party has just won the elections. And I can tell you, the minority religious communities, including the Muslims, will be very happy that India is a secular country. Because everybody's rights will be protected. And that's the strength of a secular constitution. But nevertheless, that is our constitution. It works on the Westminster model, it worked for us so far, and the question is, will Hudud change that basic structure? In my opinion, as a lawyer, I say yes. It most certainly will change the basic structure of our constitution. Could I have the next? Now, I have put up 2 slides on our fundamental liberties. But these are some of the things, some of the reasons why the Hudud may well offend the federal constitution. Now, no person shall be deprived of his life or personal liberty save in accordance with law. That is one of them. So, as Chee has already pointed out, you can only have one criminal justice system. All right? When it is a life sentence, all right, it is very, under the present system, before you impose a death penalty, it's a very serious issue. And there are many, many safeguards that are built into the system. That's the system we have at the moment. Now, the Hudud system would be different. The way in which they arrive at the decision to stone or for a death penalty would be different. So there is a possible infringement of Article 5, because there's a right to life under Article 5. All right, I just put in no person shall be held in slavery, just to show you that these are all our fundamental liberties under our Constitution. We have Article 7. It says no person shall be punished for an act or omission which was not punishable by law when it was done or made, and no person shall suffer greater punishment for an offence that was prescribed by law at the time it was committed. Then we have 2. A person who has been acquitted or convicted of an offence shall not be tried again for the same offence. This is the double jeopardy point. And actually, it happened recently under the PAA, where people were released and charged again. That is one of that is actually that offends this provision of the Constitution. Then, next slide please, you have Article 8, equality. Within Hudud itself, there is discrimination between men and women. And actually, I would like to hear the opinions of the women. I really would. Maybe you don't mind, but perhaps for your daughters, you should really be looking at the manner in which this law is proposed to be implemented. You've already heard, and I think Terengganu enactment, a woman who reports she is raped, now this is from Zainal Anwar's paper, who reports she is raped will be charged for Gaza, how do you say that? Gaza. Slanderous accusation, and flogged 80 lashes, and if she's unable to prove it with the evidence of 4 witnesses of 4 just men. Now, 4 just men would not stand by and watch a rape happen without intervening. Now then, an unmarried woman who is pregnant is assumed to have committed zina. And in fact, of course, a woman cannot be called as a witness. So, and neither the evidence of a woman and a non-Muslim is much lower. In fact, I don't think they are allowed to give evidence in certain instances. It is the evidence of men. So, there are obvious inequalities within that system. So again, how does that sit with Article 8, which ensures equality before the law for all, gender as well? Gender equality is also assured. So that's Article 8. Now I put in Article 10 and 11. Why? Because I want to show you, I also wanted to make another point about human rights. The Prime Minister, of course, has come out and corrected the statement that he made a few days ago, where he talked about human rights. Human rights, what are human rights? Human rights are inalienable rights, which you get the minute you are born. The minute you are born, by virtue of the fact that you are human, you have human rights. Okay? And these are some of the human rights. Freedom of speech, freedom of assembly, in our federal constitution. So nobody can take that away from us. You may not like it, but it's there. Now, I want to talk about, I want to just read Zaina's paper, a little bit from Zaina's paper on gender. This is what she said. PAS and UMNO leaders need to recognize the huge public divide, even among scholars of Islam, on the application of Hudud this modern age. There are those who believe in the immediate enforcement of Hudud, as many PAS members and supporters do, and even some in UMNO. Others believe it is dependent on the pre-existence of a just society, so that any violation will constitute such an affront that merits severe punishment supported by the community. So this is what Zaina is saying. There are differences in opinion. And here's the thing. Now, God is perfect in all our eyes. Islam is perfect for the Muslims. Christianity is perfect for the Christians. Hinduism is perfect for me as a Hindu. But we are not perfect. Humans are imperfect. And that is why there are differences in even the interpretation of God's law. If that is the case, is it safe to accept one school of thought and say, this is right, and this is what I'm going to do, particularly where the penalty is extreme, and nobody can deny it's extreme. It is, in fact, the most extreme form of punishment. When it is so extreme, what is the path that should be taken? I'm urging this opinion on those who are talking about Hudud. The path of moderation, I would have thought. The path of reasonableness. The path that allows you to be a modern Muslim nation living in this globalized world which enjoys universal principles of human rights. And Malaysia has sat on the Human Rights Council. We like sitting on the Human Rights Council. We always want to be on the Human Rights Council. We now want to be on the UN Security Council. We want a seat. We want to be part of the globalized community. Where does this sit with that aspiration? Now, the other thing I want to add, next slide please. This is important now. This is the oath a member of parliament takes. And I read, I, having been elected, etc., etc., I do solemnly swear or affirm that I will faithfully discharge my duties as such to the best of my ability, that I will bear true faith and allegiance to Malaysia, and these are the key words, will preserve, protect, and defend the Constitution. Every MP, past MPs included, UMNO MPs included, have taken this oath of allegiance. They have taken an oath to defend this secular constitution. They cannot go back on that oath. That is the oath of Parliament taken to defend the constitution. That is their responsibility to the people. Now, this is where I want to talk about the role of parliamentarians for a minute. And I want to talk about defending the constitution. And I want to say that we are in this position that we are today because the Constitution has not been defended enough in the past. Go back to 1988 crisis. That was an assault on a key institution under the Federal Constitution. What did MCA say then? What did MIC say then? What did all of us do then? I know that lawyers did well. We were the only ones saying this is going to cause a problem. And every time there is an assault on the Constitution, I guarantee you we live to regret it. And we're living to regret that today. You know it. You know, you can see it. You can see what is happening. Now, and then, Election Commission, sorry. This is why I will not be invited again. The Election Commission. We all know the elections are flawed. MCA knows it, we know it. MCA knows we know it, we know MCA knows it. MIC knows it. The whole country knows it. Alright? Yet, you choose to allow this Election Commission to run a flawed election. That's an assault on the Constitution, let me tell you that. Because the Election Commission is appointed under the Federal Constitution. They have a duty to, and they have to, behave in a manner as to enjoy public confidence. We allowed that to pass. We have allowed many things to pass. Today, and now you can make a difference. As we speak, charges are brought against only the opposition for sedition, non-stop. Every week I read there's another opposition member of parliament. Will MCA speak up against it? Because I'll tell you why. It is an assault on our parliamentary democracy. You beat them at the polls if you want. You don't beat them this way. You don't decimate the opposition. You have 153 seats, for goodness sakes. This is not the way to run your parliamentary democracy. And I'll tell you what it means. It means you have no respect for a voter's right to choose their member of parliament. That's what it means. That's why it's an assault on our parliamentary democracy. It undermines our federal constitution. That's my rant, okay? I will stop with that rant. But the reason I'm saying this, and I'm passionate about it because I lived through that time. Chee will remember, 1988, we were begging the public to stand with the bar, to say this we will regret in the future. Don't let this happen. But everyone was silent because we were doing well, we were rich. A lot of people were not interested. But now they're saying, oh my goodness me, what's happening? You know? That's why I'm telling you, if we act on principle every single time, we will never go wrong. My appeal to all of you as MPs, I'm not only talking to MCA, I mean, MIC has got permanent laryngitis, except for perhaps Leopari and a few others, okay? You are not there as our MPs to be silent, for goodness sake. I'm begging you, from now, please act on principle. If you see an assault on the Constitution, do something. But I'm very happy NC has taken this stand, this bold stand of talking about Hudud. Now, next slide. We do know that there are several countries in the world where Hudud is enforced. All right? Now, because I only have 5 minutes, I'm going to move on. The next slide, you know this saying by Mia Mullah, right? First they came for the socialists, I didn't speak because I was not a socialist. Then they came for the trade unionists, I did not speak because I was not a trade unionist. Then they came for the Jews, I did not speak out because I was not a Jew. Then they came for me, and there was no one left to speak for me, which is why we must speak up now. Absolutely. And let them not say, because you're non-Muslims, you can't speak. ISMA has already come up with a statement to say they want Hudud to apply to everybody else. The minute they did that, it's open for all of us to speak. I thought it was open anyway. Of course we must speak. This is our federal constitution we're talking about. This belongs to all of us. It is going to change our way of life, as Azhar said. Now, I actually put up 3 slides. But I'll ask you to read it on your own because I have a few more things to say. This is the speech by the Prime Minister, which I think was a statesman-like speech, 2012, when he launched the global movement of moderates. You must read the speech. Please go home and read it, because you can even see a few of them. It says all the right things. But what they're doing now doesn't accord with what the Prime Minister said in 2012. That's why I'm surprised. Now, I'm going to finish with this. I have some things to ask of PAS. And let me tell you, I have great respect for many people in PAS. Dr. Zhu was here last week, I gather. I have the greatest respect for him. We stood together in Bersih. We stood together, including Tuan Guru. I remember in the tunnel in Brickfields, where we faced tear gas together. We were arrested together. Unit Amal was always there to help us. There are many good people in PAS. But this is my question with PAS. You fought against the system. You know the elections are flawed. You know what is wrong with the system in this country. It's rotten to the core. I'll say it. Then why are you suggesting Hudud, which can only be implemented in a just society, in your view? I don't think you can, according to our constitution. But subject to that, how can you, knowing the system we are in right now, suggest an extreme form of punishment? How can you, knowing GST is coming, people are going to be strapped, there's going to be poverty, how can you suggest Hudud? That's not a priority. We are such a divided nation today, divided on race and religion only because of a few loud voices, let me tell you. That should be our priority, uniting the nation. And there is no doubt Hudud is divisive. It will divide the nation. You can't run away from it. And that is not what we need now. Now, this is what I'm going to ask PAS if I saw them, and I'm sure they will hear me out. Having stood in the elections on a platform that Hudud will only be implemented by consensus amongst the Pakatan Rakyat, do you think you should be explaining to the Rakyat why you have changed your stand in less than 1 year? That's my first point I will make to you. You advocated the welfare state, which received wide support. What has happened to that? Now, and then I would also ask PAS, in view of what you know about our system, please reconsider. And in view of the present social situation where the country is so divided, I urge you to reconsider this Hudud bill. That's what I would say to PAS. Now I have 10 questions for all the proponents of Hudud. Their questions. First of all, the first question is, have you looked at the federal constitution? I want to know who's sitting on the technical committee. Are they constitutional law experts as well? That's my first question. In fact, are the present Kelantan and Terengganu state amendments legal? But of course they've been passed. That's something that has to be challenged in court. Second question, and it's what I've said. This move will create a deep division between Muslims and non-Muslims. Is that an acceptable situation? Is that something you have thought about? Question 3. Are you aware that many Muslims are terrified by the prospect of Hudud but are afraid to speak up? Are you listening to their views? Are you prepared to hear them out without calling them anti-Islam? And if anyone calls them anti-Islam, will you stand up and tell them that's wrong? That's my question to the proponents of Hudud. Question 5. Is there room to argue that, isn't it true that there are differing views on implementation of Hudud? Have you considered those views, number 1? And number two, have you considered the situation if you fail to reverse a punishment? Let's say after you chop off someone's hand or foot, you then realize a mistake has been made. Have you thought about that? It is not something you can reverse. Of course, it's a problem, even death penalty in our system. And that's why we say we are against it. We're against all forms of corporal punishment. Let me tell you, it's not just Hudud. We, as far as we're concerned, the bar and so on, we are against all corporal punishment. Now, question 6. Are you aware of studies that show that women suffer badly? There are those are you aware of those studies? There are many studies from many of the countries. Then, my next question is, question 7, what has made UMNO change its stand on Hudud? Question 8, if even the Sharia system as it now stands needs improvement, how is it possible to introduce Hudud? You know the problems, I think Azhar has already alluded to that. The problem between the Sharia and the civil jurisdiction. Question 9, are those who oppose Hudud going to be invited onto the technical committee? I think Azhar should be there. Now, my final question is, how does Hudud accord with the global movement of moderates? Now, I will end by saying this. Malaysia has the potential of being the Switzerland of the East. I've traveled recently to Hong Kong, to Singapore, and I'm sitting there thinking, they're getting on with life, you know. They're moving to conquer the world. What are we doing? What are we doing for our people? What are we doing to ensure that the next generation, that the country that we're building now, it will be a wonderful country for the next generation? Why can't we make that our focus? Why are we allowing people like Isma to come out? Actually, that's freedom of speech, let them say what they want, but they get a lot of coverage. To divide the nation, to attack the Chinese. And by the way, when they attack a whole community, they disrespect the federal constitution. Why? Because you're citizens. They have no right to attack communities who are citizens, asking, where did you come from? You don't deserve to be here. They have no right to do that. Because when they do that, as I say, they disrespect the Constitution. That's why the Constitution is so very important, and we must always defend it. Because with the federal Constitution, we are assured, if we follow it, we are assured of a peaceful and harmonious existence in this country that we love.